Morning. My name is Bill Rogers. I'm panel chair of the National Academies of Science, Engineering, and Medicine's panel to evaluate the quality of compensation data collected from the U.S. employers by the EEOC through their EEO-1 form file. And today represents our first public or open session where we're going to be having a conversation with David Fortney, who, from a standpoint of stakeholders, comes to us as an employer stakeholder. And as I said, this is our first of what will be many conversations with various stakeholders, employer stakeholders, data contractors, state officials who are utilizing pay data, particularly from California, and also civil rights stakeholders. And if I didn't mention the seat at your table that you represent, please do feel free to reach out to us. We want to hear from you. That we recognize that given just the state of play, to where we are today, what's recently happened over the last year or so, that we recognize that our work has always been important, but this work around identifying issues around pay equity and discrimination in the workplace it's never been more important. What I'd like to do before I introduce Mr. Fortney is just share with everybody, so we're all on the same page, basically the summary statement of task that the panel was given. And so, pardon me, I do need to read it. I'll share it with you. So the Committee on National Statistics of the National Academies of Sciences, Engineering, and Medicine will appoint, or has appointed, this is the expert panel, to review and evaluate the quality of compensation data that the EEOC collected from certain private sector employers and federal contractors between July 15th, 2019 and February 14th, 2020. The EEOC's large-scale collection of pay information affords an opportunity to review the methods used and the circumstances of the collection to document lessons learned and to identify ways to improve potential future collections. The panel will review EEOC's methodology for collecting the compensation data through the Eo1 form, as well as the EEOC's various communications with employers in carrying out the collection. The panel will consider existing data quality frameworks to assess the data collected and will issue a report with conclusions and recommendations to inform the EEOC's assessment of the data and its approach to future data collections. So as I said, this is our first open session, and where we will be meeting with different stakeholders for the remainder of this month, but moving into June, July, and August. So we really value each and everyone's contributions. I want to thank my panelists. I want to thank the staff in advance for just all the hard work that they've been doing, such that we can have a real thoughtful, respectful conversation. So as I said, I'm going to introduce Mr. David Fortney, and he's going to share his thoughts for about 20-25 minutes. And then my colleague, Lisette Garcia, is going to then lead the Q&A with Mr. Fortney and my panel colleagues here. And then I will close the session with thanks. And I guess also wanted to say at the outset that a lot of material to cover in a short time period. So if there are questions that don't get answered, we will, as a panel, Mr. Fortney, we will come back to you and ask if it's feasible for you to share in writing some of those follow-up questions that may arise, or other new questions that could arise. Hopefully that's okay. That's okay with you. Appreciate it. Okay, well, let me turn it over to Mr. Fortney.
Great, thank you. Just unmuted myself. Good morning, and Chair Rogers, distinguished members of the advisory committee, as well as the numerous members of the stakeholder community that I'm sure are following these developments closely, as all of us are. First, I want to thank you for the privilege to be able to present some thoughts and comments today and to try to be responsive to your questions. The work that you are embarking on is critically important to help us all address pay equity and to ensure that there's not unlawful discrimination in any pay disparities that may exist. So we have a shared goal, a shared objective, and we welcome the opportunity to be able to discuss that a little more fully. At the outset, I would also like to acknowledge the assistance of some of my colleagues in supporting my efforts today. That includes Burton Fishman, Anita Beecher, and Adriana Jones from our team, who've been very helpful in getting things pulled together. Well, let me do this. I think that I've got a very brief PowerPoint. Don't worry, I'm not going to just give you a solid PowerPoint. This is going to be very interactive, but I think it will frame out some of the basic issues and might help inform the discussion. So if it's all right, I'd like to take maybe 15 minutes or so. And I see Mr. Grimes is pulling that up. So just the next slide, briefly. We'll go to that. Just by way of background, as Chair Rogers noted, I do represent employers, and that is what my practice is. My practice is almost exclusively involved in dealing with the issues that we're discussing today. So it's something that I have an acute personal and professional interest in. My prior experience also includes serving as the deputy and the chief legal officer at the U.S. Department of Labor. So I do have an appreciation as to the important policy as well as enforcement issues that underlie and inform what we are addressing today. I'm also with the Institute for Workplace Equality. I'm a co-founder of that, and its goal, it is a tax-free organization focused literally on what we're talking about today. So I'm hoping with that experience, I can provide you with my opinions. I am not here on behalf of any client. I'm not advocating for any organization or client. These are my personal views. So with that, by way of brief explanation, let me just jump in with some initial thoughts. Next slide, Eric, please. The purpose of collecting, first of all, as I indicated, we are aligned. There is an important goal that can be achieved. At this point, because this is kind of, if you will, the 2.0 version of collecting pay data. We spent a lot of time, the stakeholder community and an advisory panel from the National Academy of Sciences, looking at this the first time. We now have the experience of the commission having conducted pay. I think there are some lessons learned that I'm hoping we can learn from that and improve going forward. First, some basic observations. I do not think that the component 2 methodology that we saw for the last 2 years enhanced the agency's enforcement efforts. And we were disappointed that the agency at that point did not take some of the recommendations that had been provided from prior advisory panels. We believe this is the opportunity now to rethink some of these issues, and we hope that we will do so. All right, threshold question. Next slide, please. The threshold question is, what is the purpose we're going to achieve? And different stakeholders have different answers to this, but we need to be aligned, in my view, on what the purpose is. When I look at the EEOC's website as of yesterday, the EEOC says that it is collecting EEO data for 3 purposes: enforcement, self-assessment by employers, and research. So I will defer to this panel and your expertise on research and how the data can be used. I'm going to focus on the utility of the information, the pay data being collected for enforcement and self-assessment by employers. That helps inform, that is the organizing principle that then defines what data we're collecting, how we collect it, and its utility. All right, next slide. We are, of course, this is not an exercise that occurs on a blank slate. It's not like we have a whiteboard in front of us and we can sort of do whatever we want. The EEOC is an enforcement agency. That is its principal purpose. It has authority provided under its statute. And the statute specifically says that it is to focus on data relevant to the determination of whether unlawful employment practices are or have been committed, and related record keeping. So that is our focus. and the want to note that the EEOC has already looked at some of the structures that were put in place. These are the statements from the Federal Register, so this isn't my opinion with the quote and the site, so anyone can cross-check it. The EEOC so far has rejected using individual employee data, so they want to use aggregated data to assess the existence of potential discrimination. All right, next slide, please. So we have the statute, and then the second legal guardrail or confine that we have to be mindful of is the Paperwork Reduction Act. And the PRA, as they call it, has a specific purpose. It notes that the government has vast authority to compel the collection of data, but it also puts some limits on that. And basically, when doing this, EEOC has to address burden, benefit, and the utility, and all of those factors. And as I think we will discuss and is understood, as you get data that might have greater utility, it also has greater burden. And so the balance, there's these factors, there's sometimes a tension between and among, but all three factors ultimately have to be fully satisfied to pass muster under the Paperwork Reduction Act with the data collection tool. All right. Let's start with the next slide, Eric, please. Let's start with the concept of the EEO-1 form. That is the construct that has been used. And the question is, and I think everyone's familiar, we'll talk for a moment, what that EEO-1 form looks like, the 10 classifications. Remembering what are two, I'm going to let the experts on my screen decide the research value, but focusing on enforcement and how employers can use the data. We'll start with what the EEOC has said. It does not, the EEOC does not expect that the data will identify specific, similarly situated comparators or establish pay discrimination as a legal matter. That's what the commission has said. So that suggests that it has a more of a tangential link to enforcement. I take the EEOC at its word. I will tell you that in my view, the governing standard under Title VII, similarly situated, certainly the data collected under the current composition does not meet the standard, as the commission has conceded. And the Equal Pay Act, which are equal or substantially equal jobs have to be compared, we're way far away from that. I also want to note, as we think about what the EEOC should be doing in this space, and as many of you I'm sure know from your, if you will, day jobs, when you're not part of this advisory commission, there are a number of government agencies that are currently collecting individual pay data for different job titles. The Bureau of Labor Studies, which we understand the EEOC is coordinating with, we applaud that. The U.S. Department of Labor also issues wage determinations for jobs by individual job, individual title. They do this for prevailing wage purposes, both for service employees and construction employees. They do it for each job title, each occupation, and they do it by region, and they do it frequently, supported with wage surveys, etc. So there's a lot of granular data, not to mention the granular data that the government has in its current file cabinets in the form of charges, investigations, OFCCP audits. There's a huge amount of individualized data that could be mined to determine. All right, let's probe a little further. Let's assume that the EEO-1, the next slide please, Eric, that the EEO-1 data it would be used again. Respectfully, I believe that has three fatal flaws. Number one, the EEO-1 job categories over aggregate. They put wildly dissimilar jobs in. All of you on this advisory committee fall, of course, into the professional category, as do elementary school teachers, a variety of different consultants. There's a wide range of professions, jobs that fall within the professional bucket, if you will. In fact, when you look at the EEOC's own guidance, there are 7 pages of professionals. And trust me, They are paid very differently, very, very differently. Their duties are very different. They are not similar. So we have this aggregation problem with the EEO-1 form. The W-2 box. The W-2 box, respectfully, we believe is over-inclusive and also provides misleading indicators. And I'll give you a quick example in a moment to show that. And then these salary bands that were imposed, I think that we can look at an alternative that does not require the salary bands, because those did not help inform or distinguish who's similarly situated or whether unlawful discrimination existed. All right, next slide, please. So I have some concerns about the utility, but perhaps more importantly, the Labor Department had concerns about the utility. The OFCCP felt strongly enough, they published a notice in 2019 in the Federal Register. The component 2 data does not, because it doesn't have significant utility, because it's aggregated in nature. So for an enforcement agency like OFCCP to ferret out whether there's been unlawful discrimination, OFCCP, one of the primary customers, users of the data, has said, thanks, but no thanks. That's a concern, a big concern. Next slide, please. So these job categories, take a moment to refresh you. These are the ones that are in the EEO-1 form. It does not, similarly situated is what Title VII requires to prove there's been unlawful discrimination. You compare, if you will, apples to apples. Very, very simply stated. You don't compare apples to watermelons or apples to something else. And what we know, and I don't think this is seriously disputed, I think the OFCCP, EEOC, and I am fully aligned on this. These 10 categories have very different, disparate groups of employees in there that are not similarly situated in terms of job duties and responsibilities. That is the organizing principle. An example of what happens if you try to assimilate dissimilar people to frame and say, well, there must be an unlawful claim here, because we have, in the case of Oracle, that the Labor Department recently litigated, it said everyone who's an engineer at one of the world's leading technology companies, they put them all together and tried to conduct an analysis. The court, following a full hearing, detailed factual findings, issued a nearly 300-page decision. And one of the key shortcomings of the claims was, he was critical of the government, saying, you didn't put together similarly situated employees. Simply saying they're engineers, that isn't enough. Well, that's just engineers. That's just one, if you will, job title, one type of job title that's in that second classification called professionals. When you add clergy and all the others, you can begin to think about how disparate those jobs are and dissimilar. Next slide, please. All right. The second component is, if we're going to use the EEO-1 form, which obviously I'm not a fan of, but if you are, then it's going to be, what are we going to collect? The answer in the past has been, we're going to use W-2 data. W-2 data is both over-inclusive and misleading. And that is because the Internal Revenue Code dictates what is put into a W-2 form. It's not just salary. It has a number of compensation components that some employees may use or may not use. And there's some examples here: transportation, relocation, tuition reimbursements, etc. All of those, because the Internal Revenue Code says so, goes into the W-2 report. In order to try to, and some of that depends on what employees offer. Some of it is what benefits employees may opt to receive. There also is the example of it depends on how much people work. People go on an unpaid leave of absence, say for 3 months. If you compare someone that's otherwise absolutely identical, one person's W-2 earnings will literally be 75% of what the other person was. Not because there was necessarily unlawful discrimination, but because their W-2 earnings are different for that reason. Part of the answer that the EEOC tried to bolt on was, well, we'll look at hours worked. That only addresses one concern, and the concern The response, respectfully, was not a good one because it created these artificial defaults, 20/80, 10/40 as being full-time, part-time, recognizing at least that most people do not track actual hours worked by, particularly by exempt employees. And I think you can ask many exempt employees who've been working during the past year during COVID. 20/40 is probably not the number of hours they actually work. Many work many more than that. All right, next slide. This is just to refresh you. A hypothetical, but the data are not far off from data that we see. Obviously, Tinkers, Evers, and Chance, for those of you that are baseball fans, will recognize those, but made up names. But it does illustrate in real terms the types, if you look, they all have a $50,000 base salary, but even in this very simplified example, and assume that they all work 12 months, their W-2 earnings are radically different. You want a 401k, are you making a 401k contribution, a makeup contribution, yes or no? HSAs, yes or no, dependent care, etc. And there is a long list that the Internal Revenue Service provides that is required on what gets put into your W-2 Box 1 earnings. This is the reason that W-2 does not enable us to go apples to apples, even if someone is paid $50,000 a year. All right, next slide, please, Eric. The salary bands. The salary bands were developed by the EEOC primarily from looking at the public sector. And the public sector is a very different animal from the private sector. Public sector typically has much more regimented and often published pay levels and smaller increments in between. And many of the public sector, in fact, are subject to collective bargaining. And those that are not, their structures, their pay structures resemble collective bargaining compensation. It appears that what the EEOC hoped to do was taking these 10 classifications from the Eo1 form and then to use these pay bands to try to define who's similarly situated. And then by bolting on the hours worked to try to convert everyone to an hourly rate. Respectfully, that doesn't work. And certainly in my practice, we would never do that in assessing compensation. Again, these salary bands, and particularly looking at band 12, 208,000 over in the professional category for openers, you have a whole bunch of people that are north of 208. So the salary bands, the utility of the salary bands was lacking and added complications and work and just didn't bear any fruit. Next slide. So, recommendation, how to fix that. One, use annualized base pay. I have said this before, it's not a new position, but it will eliminate all of the problems that I've just highlighted for you. Second thing that it does, base pay is in most employers' human resource information systems, HRIS system. That is important. Most jobs, in my experience, have a base pay. They have an annualized pay amount associated with them. That's how businesses run. And jobs are scored. They have that. That's part of the HRIS system. And I will tell you from my experience, determining what the annualized base pay is for most positions is a pretty light lift for most companies. And indeed, it is the basic cornerstone that we use when we look at pay equity to help determine whether there are potential disparities. And if there are, then we introduce other factors. I know there's sometimes a question, well, what about all these other components of pay? Bonuses, commissions, and stock options, and so forth. A couple of points. Over 90%, actually over 95% of workers' pay in the United States are base pay. There are other workers. They get more of the headlines, more of the attention as you go further up the organization, and it gets narrower. But there are employees towards the apex that have additional components in their pay. The vast majority base pay is the principal basis on which their compensation rolls, and that is why we, as practitioners, use base pay as the starting point. Next slide. Just about there, Mr. Chairman. The collection of data. The pay data is really, I will just share with you from the employer, it's kind of one of the crown jewels, and it is normally very closely guarded, and employers do understand that when the government compels disclosure, disclosure is made. Would just note that there are very significant differences, and you, I think, could address this in recommendations, and respectfully, I would suggest you do so. The EEOC has criminal provisions under, what, if you will, Title 18 of the U.S. Code, Title 18 criminal provisions. So the EEOC is the agency that collects it. Then the EEOC passes it from its building in NOMA. Dr. Hafer and his team pass it over, and they provide it to their counterparts at the U.S. Department of Labor, a couple blocks away in the Francis Perkins building. There's a big difference, though. Once it hits the Francis Perkins building, the protections afforded to the data are very different. Now we're down to the Freedom of Information Act. Now we're down to principally Exemption 4 of FOIA on whether it's confidential proprietary. At the moment, there are hundreds of FOIA requests pending. There's FOIA requests from the reporter for USA Today. There's pending FOIA requests for the Center for Reporting from the West Coast. Dr. Klein from Berkeley, hundreds and hundreds of FOIA requests that the Labor Department is currently working through. That is one concern. And there's also, sometimes there has been litigation over the FOIA. What's there, what's not there. It's very unwieldy. There also have been instances, and I've detailed this in the past, where inadvertent disclosures have occurred in response to FOIA that should not have occurred. In contrast, having been a bit of a student on both agencies for measurable decades, we have never incurred that type of problem with the EEOC. Respectfully, I believe it's part of the agency's culture and the understanding of Title 18 obligations. It is in the DNA, and so far, knock on something here, it has not been a problem. All right. Key takeaways, and because I know you want to spend time having a discussion, and I welcome that. First step, the EEOC, or you as the advisory committee, you need to answer the most fundamental threshold question. What are we going to use the data for? Why are we collecting the data? That's the only way you can assess utility, usefulness. It informs everything. And respectfully, that can't be answered after you get the data. You can't say, well, just get some data and we'll sort of look at it and think about what to do with it. No, this is a threshold question. Number two, for the reasons described, we did not find the initial component 2 data that was collected useful. I don't think the agencies used it for enforcement. We know the OFCCP did not, they so said it. I'm not aware that the EEOC has used it. And I will tell you, I'm not aware of a single employer, after going through the exercise that the government required to compile and submit its component 2 report, that used the data at all after that. It was like, okay, I got that job done. It was a pain in the neck. Boom, put it on the shelf. We do not consider it when we do pay equity studies. We don't consider it when we have government audits. It's just not part of the equation. So, 3, if you're going to use the EEO-1 form, and we've talked about the 10 classifications and those limits, annualized base pay is the way to go, we believe. The salary bands, not only are they not useful, but you will significantly reduce the burden, which is one of our requirements under the Paperwork Reduction Act. You will reduce the burden and not diminish utility by eliminating salary bands. Don't just fix them, eliminate them. They're not necessary. You cannot use salary to determine this over accumulated group in the 10 classifications who's similarly situated. And finally, data protection protocols. A recommendation to extend Title 18 protections to the Labor Department and other agencies that would be appropriate, and I'm confident you would find the employer community and many other stakeholders sharing and joining those efforts. So, Mr. Chairman, I've probably taken more time than you wish, and thank you for the privilege of addressing these points.
Mr. Fortney, thank you so much for your thoughtful words and ideas and also most important recommendations. I'll now turn it over to my colleague Lisa Garcia, who will lead the conversation. And thank you again. Yeah.
Thank you. And thank you, Mr. Fortney, for joining us today. You know, we have a few questions that we'd like to ask of you. First, starting off with the EEO-1 component to data collection did not include measures of education, seniority, tenure, etc. For accounting for these possible sources of difference in compensation, what information would need to be collected to enable effective employer self-assessments? And which of these could be efficiently and accurately reported?
Okay, so let's, and thank you, Member Garcia, I appreciate that question, and let me see if I can address that. Number one, I'm not sure that the data that the government compels be collected is necessarily identical to the data that the employers will use, or certainly today are using. I know it's not identical for assessing compliance. They're self-assessments, okay? Number two, to the extent that the government data collection is going to align with self-assessment, which I would say would be helpful and increase the utility, then base pay is certainly the key point. In terms of additional factors, in my experience, this is more often than not how we approach a pay equity assessment for an employer. We start with base pay. Why? Easily available. You can put it in, you can look at people that are similarly situated, and you can run it and see whether you get flags. Okay? More often than not, as if you get flags, they tend to be a little further up in the organization where sometimes additional pay components are involved, or additional, we refer to those as factors, other factors that can drive or influence pay. And then the question becomes, from our standpoint, to an employer, well, what do you have in your HRIS? For example, education. They may or may not have education. Most of you have, all of you, I believe, have advanced degrees, whether it's PhD, Juris Doctorate degrees, etc. I've had the privilege of representing a number of higher ed institutions. It may surprise people. My experience has been they don't always have the details. You had the requisite degree, but they may not have the detail, the year it was earned, etc. That's true in many employers, even outside the higher ed space. So requiring everyone to provide education, for example, would not be good because many people wouldn't have that. It can be an influencer. Time in company, time in position. Those are important factors and typically would be included in it if necessary. But I think a threshold question is, if you are collecting base pay, annualized base pay, which is how 95% of the people are paid, and has a strong explanatory power, why wouldn't we start with that and have the universe of employers subject to these obligations provide that? Then, for those situations where there are flags, where there appear to be disparities based on base pay, employers would be trained through the good efforts of the EEOC and others to do follow-up assessments and understand and to develop their own data as may exist in their HRIS. I'm not sure that everyone should be required, because I'm very concerned that some of the examples you gave, not everyone's going to have that in their HRIS, nor is it required.
Thank you. So I'm going to ask a couple questions about base pay now, and in particular, you note that in the 2012 NAS report, the recommendation was rates of pay, which in your statement are equated with annualized base pay. Rates of pay generally mean full-time equivalent. So is your preference to use the BLS definition in the occupational employment statistics?
When we talk about it, so again, you approach it from your standpoint as a researcher. The term, in my experience, that companies use may or may not foot specifically with the BLS definition. The term of art it's a broad one. It's annualized base pay. And companies start with, very few exceptions, will score a job as to what the annualized base pay is. It may have additional components that can be added to it, but I would be happy to look more closely to see how that the BLS definition foots with what I expect is a little looser, a little broader definition of annualized base pay that the employer community uses.
Yeah, the note I have indicates that the OES includes additional things in earnings like base pay, commission, cost of living allowance, hazard pay, et cetera. So the amounts, you know, there may be variation there,
Right.
but kind of
Excuse
keep,
me.
go ahead.
Remember, that's the reason that we focus on what we call base pay. I mean, the operative word, I think, is not just annualized, but base. That is the concept. There are, you know, regional, there's a number of other variables. So I'm sorry, continue.
No, it's fine. So, you know, I have a series of questions here about recommendations regarding annual pay rates for different types of employees. So non-exempt hourly employees, you know, non-exempt part year hourly employees, non-exempt employees who are not paid hourly, but via piece rates, commission, miles traveled, et cetera. So what would your recommendations be for calculating their annualized base pay?
Companies, employers, when they look at a job, they have a concept of what the annualized base pay is, irrespective of what the mechanism is, the means by which it is earned. They have a target amount. That's how budgets are built. That's how productivity, profitability. I mean, there's any number of yardsticks that go into that. Many of those additional factors that you've introduced are individual productivity, whether it's piece rate, miles driven. I mean, there's a number of compensation schemes to take that into account. But the base pay concept is broad enough. Remember, we're talking about a data collection tool that will work for 95,000 employers, plus or minus, you know, 100,000 employers, whatever our number is at this point, a lot, with many different industries and sectors, some of whom have robust data, many of which smaller mid-sized companies do not. So again, I think if you would put forward the base pay, and companies will have an answer to that. And the answer may take into account, look, if you're a driver and we pay based on mileage, we have a target. We know how many miles we routinely are going to require you to drive. We know what the calculations are for the mileage. And so we know that your base pay, when we're done, that's what the target is. And we use that. I mean, I think that all of those other factors, that granularity, I can appreciate why for research purposes, that would be terrific. But without to diminish that, that's but one of our three goals. And I'm not sure that it would fit very well across the spectrum for all employers.
Thank you. You indicate that the use of the W-2 to measure pay is overly inclusive. What is your sense of the size of the bias that's associated with that? And do you know if and how it tends to be associated with reporting fields, sex by race, by occupation, for example?
I don't know that. I mean, honestly, we in the compliance world, my world, we don't use W-2 data. I mean, it's no more simple than that. We just don't use it. And I think that so I think that that's, you know, we just don't use it. We look at the annualized pay, at other components, but W-2 is not what drives us. For all the reasons, I mean, otherwise we have to do exactly what EEOC was trying to do, which is to effectively annualize. I mean, that's effectively what they're trying to do, is find some comparator by converting all these salaried and pay structures down to hourly rates. And I see what's trying to be done, but that's not how we look at pay. It's not how we assess pay. And in my experience, that's not how the enforcement agencies enforce pay. That's a construct that's quite foreign to what we do.
Thank you. In your public comments, you reference an internal analysis that was done by one of your member firms, and you indicate that the analysis determined that pay data was of poor quality for the purposes of identifying wage discrimination. Can you provide further information about that analysis, the approach that was used, and the data that was examined?
With some limitations, because what we did was we had just done a detailed pay study for an employer, happened to be an employer in the higher ed space. We went through that, and then at that point, the W-2 metrics were being announced. So we said, okay, great. We have the actual data. We're now going to run those metrics, the W-2 EEO-1 using W-2 metrics, and see how they compare. And as we detailed, we found that there were false indicators. The majority of false indicators were that the EEO-1 effort identified flags that were indicators that there potentially was discrimination, when we knew that when we looked at similarly situated employees, there was not. So we would call those a false flag. About a dozen plus instances that occurred. There was one where the indicator from that, I think, did overlap and coincide with our assessment. There also, by the way, was at least one instance where we found there was a disparity that the EEO-1 data did not identify. So we found, I can't say that that's a completely scientific, we did it because it was convenient to do, but that doesn't surprise us, because I think that the EEO-1 W-2 data both over and under predicts and results would result if we continue to use it, and certainly if the agencies are going to try to use it to identify where to investigate, where to bring enforcement. Our suggestion would be if they're going to, in the vast majority of times, they're going to be pursuing false indicators, and that's not in anyone's interest.
Thank you. In the letter that you had submitted in the appendix, there was a calculation for time and dollar burden for each company. Can you talk a little bit about how that was estimated overall?
Yeah, we went through the Institute for Workplace Equality, formerly was known as the OFCCP Institute, but we went to some of the, these tend to be larger, sophisticated employers that have pretty robust HR and compliance staff, pretty robust HRIS systems. So it wasn't that we had rooms full of people with green eye shades manually doing things. So their approach is, okay, we have all these systems in place. What is going to be required for us to perform the functions that are being required of us? And the key outtakes of that were that the HRIS system had to be queried in a way that's typically not, that the payroll system had to be queried in a way it typically was not. Then those two results had to be largely manually matched up, put together, analyzed, and then dropped down into Excel format to deliver the mandated government report. So what organizations did was they took the amount of time, and they have a rate. You know, they value the employee time, so they have a burden rate that they put on it, and came up with those calculations. We other than saying, you know, here's what the requirements are, and there were variations, obviously, from employers, depending on how robust or non-robust their systems were, etc. But those are the results.
Thank you. You talked a little bit about the challenges associated with pay bands and have suggested using annualized base pay. So in your opinion, are you saying that employers would submit to the EEOC annualized base pay for each employee?
Well, you know, that is the question. If we're going to use salary bands, number one, we need to move from the public sector to a more realistic sector, if that's the point. But what, I'm still not quite sure what the purpose of the salary bands is, because it appears to me we're taking the EEO-1 over aggregated groups, and then we're trying to use salary or compensation levels to determine who's similarly situated. That doesn't work. That is not how we determine who's similarly situated. We determine that based on job duties. This is the inherent tension and limitation in the data and the method it's being collected, the method by which it's being collected.
Okay, so we have time for just a few more questions, and I'm shifting gears a little bit to talk a little bit about the issue around transparency.
Yeah.
And you've raised the issue of data security at the EEOC. And since 2016 and accelerating during 2020, many companies have elected to embrace data transparency, releasing their EEO-1 reports, including component 2 pay data. And this year, most major companies have made public commitments to racial justice, both internally and in society more generally. So do you feel that these new commitments change your coalition's position from one of data confidentiality to one of transparency?
No, and I'll tell you why. Whether a company does or does not disclose, there's a slew of reasons that go into that. Social trends you've identified, being competitive in the competition for talent, and a number of other factors. But remember, what we're talking about is what we're going to subject, again, 100,000 employers to. Although the headlines are filled with examples, high-profile examples of certain employers disproportionately in certain segments, in fact, wanting and voluntarily disclosing, the truth is the vast majority of employers opt not to, and they do not want to, and they have a number of reasons why they don't want to. And so I think that it's a very big leap for the government to compel a public disclosure of that type of data. I mean, we're talking, you know, yes, there are some headlines, but I would suggest, what is it, 1%, 2% of the employers that currently voluntarily disclose? I'm not sure that provides much of a basis to require the remaining 98%, if you will, to disclose.
Follow up to that, would you encourage the OFCCP to release EEO-1 data for government contractors in a manner similar to that of the SEC on firm financials or the EPA on toxic discharges?
Not at this point, no. We have clients currently that are, look, we have clients right now that are in the middle of, as I mentioned, there are hundreds of FOIA requests pending before the U.S. Department of Labor. I mean, this is part of the disconnect. The government collects the data. The collecting agency has a criminal restriction on it. It shares it with another agency that has FOIA, or the entire world goes to the agency that only has FOIA protecting it, and they're all gathered up there. Now, again, I'm representing dozens of companies in those pending FOIA requests. Some are going to file objections, some are not going to file objections. And there's a multitude of reasons why. It's not a one size fits all. And most people, respectfully, when they signed up to be a government contractor, which is what OFCCP is focused on, did not sign up to disclose as a condition of being a government contractor their entire workforce compensation data. They're free to do so if they want, and there are high-profile examples of those that do.
Thank you. One of the panel members has raised their hand to ask a question, so I will turn it over to her.
Hi, I'm Lee Badgett. Thank you so much for your comments today. I have a question for you to go back to your discussion of the W-2 data.
Yep.
So, of course, the W-2 is a very complicated form in a lot of ways. There's a lot of different information there, and you were talking specifically about box 1. And although you were arguing it's kind of over-inclusive, your example suggested it could be actually under-inclusive. It takes out
right.
non-taxable income, right? So I have a question for you. Let's just say that we were going to stick with the W-2. I mean, do you have suggestions about other boxes that would be better to use? For example, the California pay data collection now is using box 5, which is the Medicare wages and tips. It's not capped. It captures basically all, wouldn't take out the non-taxable income that you pointed to as being a problem with box 1. Do you have thoughts on that? Is that a better solution?
It's an improvement, but I don't think that if you adopt that approach, which I would not be in favor of, but if you do, what do you do with the situation where the person was on a non-compensated leave for 3 months? Otherwise, they're absolutely identical. I mean, you're going to have a false flag, and as this last year has indicated, there's a lot of variability in that. And I just think that we're going to have so-called indicators if we go that route, and we're going to be chasing that ultimately there's going to be no there. So respectfully, that's an improvement. It's better, but you're not there. Correct.
Thank you. Thank you.
Of course.
Mr. Fortney, we have one more question from one of our panel members, and I'm going to turn it over to him. Don?
Hey, thank you very much. As you can see, I'm in a car. I really enjoyed this presentation, and I find the discussion about base pay very interesting for us to pursue and think harder about. And I'm wondering if one went with base pay, but at the same time you wanted to reject the pay bands, what would be the substitute? Means and standard deviations? Would it make sense for that to be at the level of those occupational groups? Or would you rather, to get the specificity you're interested in, get the means and standard deviations within the pay bands or some other distinction? Thank you.
So the question picks up on a point that to increase the utility of the data, you necessarily have to have it be more, if you will, granular, whether it's by occupation, etc. The problem we talked about before, then the burden goes through the roof in doing that, as does the importance of confidentiality, etc. The more granular you get. We do recognize, because that's the reason when we, in private compliance efforts and assessments, we look who are similarly situated, and we do so based on job duties. Of course, with each company, because we find that they're not consistent. That case I highlighted for you, the litigation where all engineers at Oracle could they be somehow found similar? And by the way, they attempted to follow the human capital theory to use that to organize who was similarly situated. Okay, the judge, no, that's not going to do. So if the government would go the route that the question posits, it would make the data more useful. It would increase the burden significantly, very significantly, but it would start to move closer to how employers do look at it for their own compliance. The difference is when we're dealing with our clients, more often than not, it's because they want to. It's their best practice. They're doing it. We're talking about a government compelled exercise. And by the way, it currently is once a year. It doesn't need to be once a year. It could be every 5th year. There are ways, again, as a former policy person, there might be ways you think about burden to lessen that. And frequency of collection would also be a point to consider. But thank you for that question. Drive safely.
We are just about at the end of our time for the questions, and I just have one more to ask, and that is that your testimony didn't include the list of the firms who are members of your coalition. Is that a list that you can share with us, and can you share with us which have made public comments regarding transparency to the EEO-1 data?
I can check on that, sure. I mean, we in terms of members of the Institute, yes, that's certainly public. And we will cross-reference and do that. That would be one. In terms of initially, we also had some employers that came together just as kind of an ad hoc coalition that were interested. Part of what they wanted was anonymity, so that part I cannot do. But I can give you a partial yes. We'll use best efforts and circle back on that and do a submission.
Thank you.
Of course.
Bill, I'll turn it back over to you.
Great. Thank you, Lisette, and Mr. Fortney, thank you. And then let me just give you maybe another 30 seconds if there are any summary points that you want to make. I'll offer you that.
No, I appreciate that, Mr. Chairman. I think a couple of things. It feels like we're stuck with the EEO-1 form. Okay, that it doesn't need to be that way, but it feels like from your questions that continues to be your thinking. You could reimagine a different data collection tool that doesn't have those 10 classifications, because that creates part of the struggle. Everything else you're trying to engineer to overcome that conceptually. That's one. Two, the utility and the burden cannot be ignored. And with all due respect, what you all find for research purposes to have great utility and that it might impose some burden, in my experience, has not translated very well in terms of utility for compliance, and I've not seen it used for enforcement. So I would encourage that those points, it's a holistic, it's a very challenging problem, and each of these points are interrelated. We recognize that. And we will work with you in any way we can, and we'll do some follow-up. Member Garcia has requested some, and we're happy to do additional follow-up if that would be useful. Okay.
Great. Thank you so much. And I think we will take you up on that. And as I said, showed you in the before we went public, we were kind of in the waiting room that you are our first guest. So we're really on a listening tour. That I don't think any sort of thoughts or decisions have been made. There's no recommendations that have been developed. We truly are at the beginning, and we really want to do this full 360 degree review, and as long as it's consistent and stays in focus with our statement of task. So with that, again, thank you so much for taking the time with us this morning. And
appreciate the opportunity to be part of it. Thank you.
Pleasure. Thank you. We'll follow up with you. So Jen, I think we want to, I guess we'll close the open session.
I'll step off at this point and let you all go to do your wrap up and so forth. But thank you all very much for the privilege of being here today, and have a safe and happy Memorial Day weekend.
Oh yes. Thank you. You too.
Remember our troops. Thank you.